I'll even have plenty better. All right. I actually left my whole bio sheet on you at home. So I'm going to give a very poor and short introduction. But Professor Wasby is retired professor of political science, has a specialty in federal courts, taught a number of places, mostly at SUNY Albany, is that correct? And has retired and been living in the Cape for something like
half a
dozen years. And this, I believe, is the fourth or fifth year that he's come in to give you a lecture on the federal court system. And the beauty of it is that this is the, just as you're starting your unit on the federal courts. In fact, they read your article on summarizing the federal court system, and now they're reading the textbook chapter on the court system. So at the end of this, you will know the court system well. And frankly, in this unit, that's the challenging part. The stuff on civil liberties and civil rights is you know, you'll be instantly engaged in that. You'll get that. The mechanics of the federal court system is a bit more of a challenge. So Professor Wasby has done an excellent job in the past of helping us to do this, and he will guarantee you a 5 on the AP if it's all about the federal court system.
I didn't say that.
Okay, so Professor Wasby, thank you.
Good to be here. I'm not ill. This is the end of a long cold. I will turn to my terrible diagram. I almost flunked art in the 8th grade, and my diagrams prove it. A word about this first. No, there is no quiz in 15 seconds. The cases decided in the federal courts appear in a number of different series of volumes. You haven't done any basic cite exercise with them about how you cite a case?
No.
All right.
No, we haven't.
All right. Little exercise here. The decisions of the U.S. Supreme Court appear in a number of different types of volumes. The government itself prints something called the U.S. Reports, cited that way. One of the things about, for those of you who are used to doing bibliographic work and doing footnotes on bibliographic items, you're used to putting let's say the name of the journal or magazine and then the volume number. In lawyers, put the volume number first. So if you see this, this is a hypothetical. That's volume 356 of the U.S. report. And the number after is the first page of the opinion. Let's say you were quoting from page 35, you do this. Okay? Now, there is also something called the Supreme Court Reporter that is privately published, and I think we're in something like this. Again, that's cited as S period, CT period. Again, both of these are U.S. Supreme Court opinions. But that's only the U.S. Supreme Court. One of the points I'm going to make today is that most decisions, let me start that sentence again. With the U.S. Supreme Court deciding only 70 to 75 cases a year out of some 8,000 requests for it to hear cases, that's not very much. What happens to the other cases? Well, they end at a lower level, almost by definition, and I'll talk a little bit more about that later. That basic level at which they end up in the federal system is the U.S. Courts of Appeals. Those opinions appear in what is known as the Federal Reporter, cited as F. Except that there got to be so many volumes, they decided they had to start over again. And so we then got what is known as Fed Second, Federal Reporter Second Series. And if you look at the cover of that book, it is Federal Reporter Third Series. So I have in my hand up here, volume 645. notice again the number of the volume first, and then whatever the case. 645 F third is not the same as 645 F second, is not the same as 645 F. If you think you're looking, if instead of looking here, you look here, you're in the wrong place. You follow me? Okay. Now, these paperback volumes are called advance sheets. Actually, when the case comes down, you get a little slip, what's called a slip opinion. Looks like a little pamphlet. But after that, it goes into these, then technical corrections are made, then it comes out as a bound volume, which goes into the law library. Now, of course, a lot of lawyers are now using electronic stuff, and tied to this, notice it says West, this West Publishing, part of Thomson Reuters now, as a matter of fact. West Publishing, this is a private operation, so I don't subscribe to this. I subscribe to Supreme Court Reporter. I have to pay for it. That's a private subscription. But you can find this stuff online. Actually, if you want to look at any Supreme Court case, go to www.cornell.edu to the law school site, and you will immediately be able to find any U.S. Supreme Court case you want. Free. That's actually the simplest way for members of the public to do it. Through my university library, I have access to something called Westlaw. You people have probably heard of LexisNexis, but Westlaw is the other major resource. So I don't need to go to a law library to check out a citation. I go online through the access code I have to Westlaw, which is where this stuff can be found electronically. But I'm a print media, hold it in your hand sort of person, given my age, and I wanted you to see what this is like. My suggestion to you, I'll let your boss decide whether he makes an assignment, is take some time just to scan through and see the types of cases that the U.S. Courts of Appeals have. One more thing, and then I am actually going to get to the diagram. The cases from the district courts, the trial courts, appear in something called the Federal Supplement, cited F Sup. We are now in F Sup second. Now I am being somewhat incomplete here because with these you've got to indicate which circuit and which year before those sites are complete. But I don't want to eat my time up doing that because I am going to talk primarily about structure. But it is my...
Just for 1 second, I apologize for my first interruption. I do expect you guys to be taking notes on this, so please make sure you have your notebooks out and are taking notes. And secondly, another site to use, which I don't remember if I mentioned before, but findlaw.com is a site at which you can find all federal Supreme Court, all district court, all courts of appeals, all state court rulings, and codes as well. It's a sort of a free version.
There's a lot more that you can find easily. Yeah. I'm just trying. Having handed you this, I needed to give you this background. All right. So I'm going to do structure, and then I intend to leave time to talk about judicial selection, particularly including judicial selection, but in this administration. All right. That's very basic, fast and dirty. Now let's turn to my fast and dirty diagram. The focus by my political science colleagues and by the media tends to be almost entirely on the Supremes. The Supremes are not a musical group. Judges themselves often refer to them as the Supremes. And it is true that despite the 70 to 75 or 80 cases a year with opinion that the justices decide, though that number may not seem large, it used to be up 120, 140. There are all sorts of discussion about why there are so few, but each of those cases is important far beyond the individual case. Because the court is taking those cases, is able to pick and choose, as I will explain, is taking those cases to deal with an issue. So, for example, one of the biggest issues presently before the Supreme Court is the challenge to the Obama health policy law. And there were any number, at least a half a dozen that I can think of offhand, cases in the lower courts. The court chose to take a particular case. Doesn't have to take the others. Didn't have to take any of them. Except this is an issue so big that the court really couldn't have hidden. When it decides that case, it's not just deciding the narrow facts of the case as the people involved. It's deciding the larger issue. So the 75 or 80 count, if you will, have a broader impact. So when the court decided Brown versus Board of Education in 1954, it wasn't merely deciding about Linda Mae Brown. It was deciding about all school children who, because of their color, were barred from going to schools with whites. But there are lots of cases that don't get to the Supreme Court. And their final resting place is basically in the U.S. Courts of Appeals. Now, one of the things I have not done here, and actually should do, we have in this country what we call a dual court system. We have a set of federal courts on which I am going to focus, and we have a set of state courts. And as you will see in a second, both the federal system and the state system have 3 basic levels and some other stuff, and I will explain that. And, so let's say that this is the state system over here, very inartfully drawn. The U.S. Supreme Court becomes the highest court in the land for state court cases that raise a federal question. So let's say that you are arrested for drugs in your car, and you think that the search has been unreasonable under the Fourth Amendment. Am I wandering wrong?
No, fine.
Okay. You would challenge the search in the state courts. Having failed, that is, your conviction having been upheld, you could still take that federal constitutional question to the U.S. Supreme Court, and as we'll see in a number of ways. For questions solely of state law, this is as far as the court, as matters would go. So if the Massachusetts, does anybody happen to know what the official title is of the highest court in this state?
We haven't gotten to that part yet.
All right, that's
but
okay.
Someone might
figured,
know.
That's all right. The Supreme Judicial Court. All right. Maybe it would be better if I started at the bottom. But my point here, having made the point, relatively few cases here of broad significance. Most cases end here. And the U.S. Supreme Court gets to pick and choose. Maybe I'll say something about that now. If you think history, one of the important things to keep in mind, the present federal court system did not happen from year one. We are operating under the Judiciary Act of 1789. As amended, as amended, as amended, as amended, as amended. But that basic statute is there. But the present structure of the federal courts didn't really happen until the late 19th century. And there are 2 years to remember. In 1891, the Congress created the U.S. Courts of Appeals, as we now know them. And that's where you took your first appeal. You had your trial. You then, whether criminal or civil, whoever was appealing took it to a body called the U.S. Courts of Appeals. More about them later. And then in 1925, Congress passed something called the Judges Bill. And it was passed, pushed through Congress by Chief Justice William Howard Taft. And does anybody here have a sense of American history and tell me what else William Howard Taft did besides being Chief Justice?
He was president.
He was president. Governor General of the Philippines, a number of other things. He's the only person who's moved from the presidency to the Chief Justice. Very interested in judicial administration. Not every Chief Justice has been. Oh, by the way, the Chief Justice is not Chief Justice of the Supreme Court. He is Chief Justice of the United States. And that difference in label means something. So he's got a responsibility, it's always been a he, he's got a responsibility for the entire system. But he took particular interest in this. Up until that point, certainly up until 1891, and still pretty much until 1925, the Supreme Court had to take every case brought to it. When that happens, we say it is a mandatory jurisdiction court. They must hear every case. That doesn't mean they've got to give oral argument for 3 hours. That doesn't mean they have to write 20 pages. They can say affirmed, period, end of story. But they've got to decide it. They can't not decide it. So starting in 1925, the Supreme Court was given the power to pick and choose its cases. It was given the power to become what we call a discretionary jurisdiction court. The discretion to pick and choose. Because it was given the power to issue writs of certiorari. Now I'm going to get you to pronounce it once, and then we'll say cert for short and be done with it. 1, 2, 3, certiorari. Some people say certiorari, and I studied Latin, and I don't think that's right. Anyhow, a definition for you. A writ of certiorari is an order from a higher court to a lower court to send up the records. An order from a higher court to a lower court to send up the records. So here's the way it works. I petition for certiorari. I ask the Supreme Court. My case is in the Court of Appeals and I'm lost, and I'm still ticked. So I want to take this further. You know, everybody says, I'm going to take my case to the Supreme Court, right? So I petition for a writ of certiorari. If it is granted, the Supreme Court said, certiorari granted. That means send us the papers from the lower courts. We've taken the case, we're going to decide it. If they say certiorari denied, end of story. Certiorari denied is not affirmance. It's very important because the media get it wrong all the time. You'll see headlines about the Supreme Court decided today, or as one of my friends wrote a marvelous article, the Supreme Court decided today, or did it, and then you find out that in fact all they did was deny review. When they do that, so notice, cert denied does not equal affirm. All that leaves in place is the earlier ruling. So on health policy, let's say they had not accepted a case. It would have meant this ruling in this circuit said one thing, this ruling in this circuit said another, and we end up with cases like that. Now I'm going to single out somebody, and please don't take this personally. There's somebody in this room with very long hair. And there was a period of time in the 60s when this was a major legal issue, as you may know. You were out. I mean, you'd get thrown out. And school principals, particularly Marines, loved to say, oh, I go to that barber, and when you come back, and no, I don't think that's enough. This is in the days before dress codes. Because this was the first form of rebellion, right? Okay? I lived in Carbondale, Illinois, taught at Southern Illinois University. 60 miles away was Paducah, Kentucky. Carbondale, Illinois is in the 7th Circuit. In the 7th Circuit, I could win your case. So we'd get a trial judge who would uphold, you'd be thrown out, your parents would sue, right? Violation of due process and everything else. The trial judge who was the district judge who was very conservative, would let you build a record, but no, you're gone. It's on your record. Sorry about that. We don't care what difference it makes about getting into college. You take it up to the 7th Circuit, and there was one judge there who said, what's wrong with this long hair? Has anybody looked at pictures of our forebears? And that would be the end of it. You'd win. In Paducah, you'd stay thrown out because that was in a different circuit. The Supreme Court never took that issue, even though the courts of appeals were 5 ways to China on that issue. They wouldn't even take a case where Native Americans had their hair cut forcibly, which I suspect you know is very important symbolically. The Supreme Court does not deal with every issue. We tend to over-attribute to it. So, the point is it would have left these rulings in place even if they were contradictory. One of the reasons that the Supreme Court does take cases, however, is that there is what we call an inter-circuit conflict. Because one circuit will say one thing and one circuit will say another. But for virtually all cases, this is the end. And there are thousands and thousands of those cases. All right. I keep saying I'm going to go back to the bottom. Let me go back to the bottom. Let me start at the bottom. Your case initially goes into the U.S. District Court. Every state, with one minor exception, which happens to be Yellowstone Park, federal districts are within states. They don't cross state boundaries. Because Yellowstone, if you've ever looked, runs over a state boundary and it's federal territory, it would be a real pain in the ass, pardon me, to have it in 2 districts, so we make an exception. That's the only one. Many states have only 1 district. You are in the District of Massachusetts. Some states have 2 districts. Some states have several, so New York has 4 districts. The Southern District of New York, which is one of the most prestigious district courts in the country, which is based in Manhattan, and is essentially Manhattan and Westchester. The Eastern District, actually New York City is in 2 federal districts, because Brooklyn and Queens are in the Eastern District. And then the rest is the island. And then there's upstate. 1 district based essentially in Albany, another district based in Buffalo. California has 4 districts. 1 based in San Francisco, 1 based in Sacramento, which remember is the state capital, so that gets a lot of the government type of cases. 1 based in Los Angeles, 1 based in San Diego, which gets a very high proportion of immigration and drug cases. So 1 to 4 districts per state. A varying number of judges, depending on how many cases. You don't need very many judges in the state of Wyoming. You need a hell of a lot in Manhattan. Actually, in Massachusetts, I should point out that while the district court is headquartered in Boston, and the next time you're up there, go out to the Moakley Courthouse on the waterfront. It's quite a phenomenal building. Some people claim it cost too much, and it really was Steve Breyer's palace. Justice Breyer was the chief judge of the First Circuit before he was elevated to the Supreme Court, and that was sort of, here's my marvelous new building. but enough of that. There are also judges who sit at Springfield. Another part of the district court, by the way, are magistrate judges. They used to be called commissioners, but everybody loves to have judge in his or her title, right? Status inflation. So they became magistrates, and now they're magistrate judges, and you call them judge. It's not like bankruptcy judges. Used to be called referees in bankruptcy. They're now bankruptcy judges. You call them judge. And some of them it goes to their head, and some of them it doesn't. Magistrates are not lifetime appointed judges. U.S. District Court judges, U.S. Court of Appeals judges, and Supreme Court justices are essentially lifetime justices. If you've read the Constitution, which you ought to, go back and read Article 3, during good behavior, which means they can be impeached, and some have, but it's essentially lifetime. No mandatory retirement. Magistrate judges and bankruptcy judges are term judges, long terms, 12, 14, well, I can't remember the years off the top of my head. They are appointed by other judges. Well, they're crucial to the system because they handle, in criminal cases, they handle arraignments and they handle petty offenses. And to go back to Jellystone Park, you violate the law. You speed on your snowmobile in Yellowstone, you have committed a federal offense. And you go before a federal magistrate. Federal is how they pronounce federal in Arkansas. In civil cases, you can, if both parties consent, the magistrate can decide the case. And sometimes you can get your case decided quicker if you're willing to go before a magistrate than if you wait for a real, live, full U.S. district judge. They play a very important role. A particularly important role they play is in something called federal habeas corpus. I'm going to assume that you know what habeas corpus is. It's a way of challenging your detention, your conviction. Let's say you've been convicted of a crime in the state courts, and your appeals have been unsuccessful. And you've got that search issue we talked about, federal question. You go to U.S. District Court, you've gone all the way up the ladder, you come back and you start, you've gone up this ladder, you come back and you start this way. And there are lots of those. If you're sitting in prison and you're unhappy, and you have nothing to do with your time but file paper, and maybe you believe you're right, and maybe some jailhouse lawyer told you, oh, there's this new case, or you found something in the library, you file a habeas corpus petition. Some are successful. But those invariably get referred to magistrates who do the thorough study of them and make a recommendation to the district judge. They play a very important role. Both our magistrates and our U.S. district judges are generalists. They are not specialists. They hear every type of case, criminal or civil, that comes before them. There are specialized courts. And you see that in the set of questions that Mr. Dixon posed for you. And I'll come back to them, and if I don't, he'll bring me back to them. But basically, in the U.S. district courts, we're talking about generalist judges. I mean, an individual judge will develop a rep for being an expert on a certain subject, but maybe will have come from a particular type of law practice to the court where there was a specialty. They are expected to hear everything that comes before them. All right. You have your case in the district court. Next step is, we're now going up. The elevator's going up. Next stop, U.S. Court of Appeals. These are no, I need to back up. In the district courts, when you appear in court, you're appearing before a single judge. There are some exceptions. We have a strange beast called the three-judge district court. There's 2 district judges and a court of appeals judge. And now that is used almost exclusively only for reapportionment cases. Every 10 years, census, got to redistrict. We've just gone through that. The minute a redistricting plan is written and approved, guess what? Somebody's in court annoyed about it. Doesn't go to a single judge, goes to a 3-judge district court. But otherwise, any district court case is a single judge. The minute you get to the appeals courts, you're dealing with panels of judges, basically 3-judge panels. So you walk into that courtroom and you've got 3 people loaded for bear. And it amazes me. I'm an appellate oral argument junkie. I love watching this stuff. I've watched more cases than most lawyers have argued them at that level. And, you know, because of TV, we overestimate the extent to which lawyers are in court, but particularly very few of them in the appellate court. And some of them come in and they haven't done what they should have done, which is going in the day before and seeing what it's like. And so they go in, and there are 3 people up there, all of them ready for questions. And in the court, U.S. court, you know, in the U.S. Supreme Court, you get half an hour aside. One of the things, and I don't know if you've seen about it, they have set something like 5 or 6 hours for the. It's going to be over 3 days for the argument of the health policy cases, and sort of have carved up the issues. That's highly unusual. That harks back to Daniel Webster arguing for several days in a row when there were fewer cases. U.S. Court of Appeals, you're lucky to get 15 minutes aside, 10 minutes aside, and that includes their questions. So if you get up there and think you're going to give 10 minutes of speech, In Brown versus Board of Education, where there were 3 rounds of argument for a variety of complicated reasons, at the beginning of the 2nd round of argument, the Attorney General of Kansas got up to speak and barely got his name out. And the question was, why are you here? Meaning, by what authority, what case do you have left after what we did in the first Brown ruling? So if you go in thinking you're going to do 15 minutes or the 30 minutes, you ain't going to do it. You got to sort of have segments that you can sort of back on. Think about that if you were ever in a mock argument situation. And people get rattled. One of my favorite stories is, and this is a true story, when you get up to address the court, you're, in addition to saying, may it please the court, you were supposed to say how your case got there. Did it come by appeal? You put this down so that I'll go forget it. Did it come by appeal? Did it come by cert? Or did it come by certification? Well, one young lawyer forgot. The Chief Justice, in shorthand, said, how did you get here? By bus, Your Honor. Laughter in the transcript. All right. And there has been some interesting byplay, again in Brown. Frankfurter, who always interrupted everybody, he never stopped being the Harvard Law professor he has once been, started hectoring the Attorney General of Kansas, and Earl Warren was Chief Justice, and right there in front of God and Company said, we invited the Attorney General to be here, and I, for one, would like to hear him sing. But once it shut Frankfurter up. Anyhow, you're dealing with panels. In the U.S. Courts of Appeals, you're basically dealing with 3-judge panels. Rotating panels. Some state appellate courts have 3 judges sit together for an extended period of time, months. U.S. Courts of Appeals rotate almost, they sit together for a calendar, which is a week, 5 mornings. And then the next month, A, who was sat with B and C, is off sitting with D and E, and B is sitting with F and G, etc. The number of judges per circuit varies. What circuit are we in? First. This is the smallest circuit. 6 judgeships. The 9th circuit is the largest geographically and has 29 judgeships. Alaska, that's the circuit I study. Alaska, Washington, Oregon, California, Idaho, Montana, Nevada, Arizona, Hawaii, Guam, and the Northern Marianas, which is an old trust territory that's a federal district way out in the middle of the water. With one, there is a Court of Appeals for the District of Columbia, which is very important because so many executive agency headquarters are there that a lot of cases have to be brought there. Challenges, environmental challenges under the, if you're challenging a ruling of the Environmental Protection Agency, has to be brought in DC. The statute says so. And it's Congress's law that determine where these cases can be brought. In other cases, you have choices. The DC circuit is just DC. Every other case, there are at least 3 states in the circuit. This circuit is not even all of New England, because Vermont and Connecticut are in the 2nd circuit with New York. So we are New Hampshire, Maine, Massachusetts, Rhode Island, and Puerto Rico. And actually, Puerto Rico and Massachusetts are the 2 districts that generate the most cases in this district, in the circuit, pardon me. Now, sometimes we've split these circuits. The court that was most important in implementing desegregation was what we call the Old Fifth, which ran from Texas all the way over to Florida. That court is now 2 circuits, the 5th and the 11th. There are always efforts to break up that big 9th circuit because somebody gets unhappy about its rulings and thinks that liberal judges from California are ruling the world, and somehow we can't have that. So we do occasionally realign these circuits. Now here's a key point. I said 3-judge panels. Let's say you lose your case before the 3-judge panel. You can then, of course, try to take it to the U.S. Supreme Court. But you can also ask the full court to hear it. So in this circuit, judges A, B, and C will have decided the panel, they rule against you. Oh no, I want the full court, all 6 of you. And that's called the court sitting on bank. E-N, some people say I-N, E-N-B-A-N-C. Sort of law French. You know where you will run across this? If you see an article which says, oh, the government lost and the government is trying to decide whether to ask the full court to hear the case, that's what's operating here. They have to operate. You don't have a right to have the full court hear it. You ask, you file a petition for rehearing on bank, and the judges then vote on whether to do it. And most of the time they say, no, you're not bringing us any new arguments, go away. Take it to the Supreme. But told you I had to deal with this. So we've worked our way back up again now, right? We're U.S. Courts of Appeals. There are specialized U.S. Courts of Appeals. One in particular. This is where the terminology gets a bit confusing. Notice I said we have a U.S. Court of Appeals for the District of Columbia Circuit. That hears all sorts of cases. there is a U.S. Court of Appeals for the Federal Circuit. And that is what we call a semi-specialized court. All patent and copyright appeals, all appeals from terminations of federal employees, all appeals in contests about veterans' benefits, and that court is based in D.C., but takes cases from the entire country. And as I suggested, there are also some specialized district courts. There's one called the Court of Federal Claims. That name has changed over time. You have a suit against the government for money, you must take it there. You can sue the government for money because the government says you can. Sort of waives what we call sovereign immunity. But you have a particular place where you have to make that claim. There is what's sometimes referred to as the secret court, the Federal Foreign Intelligence Surveillance Court, which issues warrants, meets in a secure room in D.C., issues warrants particularly in present context in terrorism cases. And there are a number of other specialized courts. By the way, the most common specialized trial court is the bankruptcy court, which you find, which is essentially an adjunct at this level. All bankruptcy cases go to those people called bankruptcy judges that I mentioned before. All right, we've gotten you up. You've lost your case. On bank rehearing has been denied. What do you do? But still, you're well financed, or you've got a free lawyer. You want to bring your case further. How do you get to the Supreme Court? Well, I've given you part of the answer. You petition for certiorari. From 1925, going back to dates, from 1925 until the mid-80s, some cases still had to be heard by the U.S. Supreme Court. They fell into a category called appeal. Again, the language is confusing as hell, because when we talk about appealing the case, we talk about taking it to the next level. This is a more technical use. If your case, and you can look at my textbook and you can look elsewhere, it spelled out the rules, and I'm not going to inflict them on you. If your case fell into that category, the Supreme Court had to take the case. So even after 1925, there was still a category of cases that were mandatory jurisdiction cases. The key thing about 25 is that it shifted a lot over to the pick and choose side, to the cert side. Then in the mid-80s, Congress was persuaded that really we didn't need even that set of mandatory jurisdiction cases. And they limited it severely. It still exists, so let me explain. I mentioned reapportionment. Redistricting cases and certain other sorts of voting rights cases must be heard by the Supreme Court. No choice. You may have read recently about a kerfluffle involving the state of Texas, where people weren't sure whether they could run for office because they weren't sure what their districts were going to be because of redistricting. The legislature had done one thing, somebody had challenged it, a set of federal judges down there had done another thing. The Supreme Court heard it, decided it within a matter of weeks. And Congress can specify that the Supreme Court has to hear particular cases. It cannot, as a matter of constitutional law, it cannot tell the Supreme Court how to decide the case. It can tell them they must decide the case. Let me give you one example. Actually, there's more than one. And I want to make a general point first. Read Article 3 Article 3 tells you very little. It says, there shall be one Supreme Court, and such other inferior, that doesn't mean worse, it means lower, courts as Congress shall establish. That's why we have the Judiciary Act of 1789 as amended, as amended, as amended. All of cases go where the districts, how many judges per district, it's all statutory. It's all Congress. Okay. Flag burning. Not long here this time, but flag burning. Supreme Court got a case from Texas challenging the Texas's law banning the burning of flags. First Amendment issue. Supreme Court, 5-4, decided that that was an unconstitutional law and struck it down. Congress, insisting as usual that it could be more patriotic than anybody else, turned around and passed a federal law banning the burning of flags. But the reason I use this example is, they said in the law, if this is struck down by a district judge, it shall go to the Supreme Court. It shall skip the Court of Appeals. It shall be heard. And 2 federal district judges, one in the Western District of Washington and one in the District of Columbia, promptly obliged, struck the law. It went to the Supreme Court, which, guess what, said 5-4, the same thing that it said in the Texas case. But the point is, Congress legitimately could say, you must hear that. All of the campaign finance laws, which the Supreme Court has been eviscerating, all of the campaign finance laws have had a provision in them. This must go to, and in this case they specify a particular district court, and it must go to the Supreme Court, and it must be heard on an accelerated calendar. No fooling around with it. So there are these isolated instances, and Congress could add more. So this category of appeal is much smaller than it used to be, very small, but still exists. What about certification? There is a infrequently used device. I just realized I missed something else. There is an infrequently used device called certification. Now, when a district court or a court of appeals gets a case, it's supposed to apply precedent. It's supposed to look to past cases. That's our system derived from the English common law. But what if it has an issue that is so new, we call it a case of first impression, that is so new, we can't find any precedent. The lawyers can't find any precedent. I mean, I'm exaggerating, but there ain't much there to provide us guidance. What do? We punt. And there is an official way to punt. A U.S. Court of Appeals may certify a case to the U.S. Supreme Court saying, here is a legal issue we cannot decide. We want you to decide it. Please. And when that happens, the U.S. Supreme Court has 3 choices. It can say, you do it first. We're not buying. You do it first. And then it will come to us in the normal court. They can take the case, answer the question in the abstract, and give it back and say, you apply our answer to the facts, which probably means it's going to come back again because somebody will complain that it's been improperly applied to the facts, right? Or they can simply take the whole case. Say, yeah, we know you want us to just answer the question, but it's simpler for us to take the whole case. The best example that I can give you is Japanese-American relocation during World War II. When, as I hope you know, the government started with the Army, but Roosevelt signed on, and then Congress agreed, ordered the evacuation, first curfew and then relocation of Japanese Americans on the West Coast. Challenged as a violation of the 14th Amendment, equal protection. But this went into district court. Somebody violated the curfew intentionally. Somebody was arrested for not moving to the relocation center, concentration camps by any other name. And it got to the Ninth Circuit. And the Ninth Circuit judges said, we've never seen anything like this before. We don't know what to do. And so they turned this over. They certified the case to the Supreme Court, and the Supreme Court, actually there were two cases. Hirabayashi case involving the curfew. No, the Korematsu case involving the curfew and the Hirabayashi case involving the relocation. And the Supreme Court took those cases and decided them. So this is a rare event, but it is a mechanism by which cases may get there. Let me point out one other thing. Usually you have to have a final judgment in the Court of Appeals. But sometimes what will happen, the Supreme Court will have one case or two cases that it's accepted on an issue, and there are several others popping around down below. You can persuade the Supreme Court to take a case from the Court of Appeals before it's decided here and bring it up. If you look at Brown v. Board of Education, Brown v. Board of Education is actually 5 cases, not 1. There were 4 from different states and 1 from the District of Columbia. The Supreme Court had accepted the Kansas case and 1 other case, and these other cases were pottering around in the Court of Appeals, and the Supreme Court said, we want more cases on this subject. We will accept them out of order, if you will. Pentagon Papers. When the government sought an injunction against the publishing of the Pentagon